course, I'm going to continue. That's the near hotel. That's your work point. Minibar. As soon as your guard shift gets enough to work, right out of our fans when you talk to your valet. Your guards will load the bags into the engineer, and then when so much as approaches the brother's doors, wiggle away. When I get word the band is away and the money is secured, my men will exit the building, and once their safety is confirmed, we'll get the ball. All right? Now, I'll comply with every request. Agreed? That works. Good. Now I have one of my own. Run up. Run and hide. You should be picked up next week by $100,000.
Hi, Brother Christensen. I'll be right back.
Okay.
What's going on? Yes, sir.
Okay. Mary's back. I don't know if you're ready to start or not, but I got to figure out what my questions were because I just finished with another class and got to remember what I'm thinking about on this class.
Okay. Hi, Mary. Can you hear me?
Yeah, the sound is good. You're like a beam of light, but your sound is great, and that's all that's really important.
Yeah.
Don't worry about that.
It's really light, isn't it? Yeah. Let's see if I can reposition my desk here. Wow, it's really bright. Jeez.
that's very good. I mean, it didn't matter necessarily the other way. Just
I've had to turn it around. 50-degree angle. So you can hear me okay?
Yep.
Okay, good. A couple other people have sent me an email saying they want to join, but let's just get started, and then, you know, if you want to leave when they come or whatever, that's just fine. So.
Hi.
Hi, Lisa. How are you?
Good. How are you?
Good to have you with us. We got Mary here as well.
Hey.
Stalwarts are here.
And Daniel. Okay, so I know one of my questions is just for sure, is exam 5 due on Tuesday?
Check real quick and just confirm the date on that. Hang on.
I thought that was already due.
I'm sorry, Lisa, what did you say?
I thought that was already due. Let's see. Due July 17th. No, that's the appeal. Is that week 12? Yeah, ends July 11th, exam 5.
Okay, so we're past July 11th. So, but you know how we can't do the pre-exam until like later tonight. And then for me, usually it shows when the exam's due, which is the same time that the pre-exam is due in the past. So I think maybe that it's due on the 18th. Does that make sense?
You mean the appeal?
No, the exam itself, I think is due on July, well, for me, it's July 18th at 10:59, so 11:59.
Are you talking about the final or exam 5?
I'm sorry, I'm talking about the final.
Okay, because that's already due.
Yeah, I believe that's correct. That's what I got here. I've got July 13th that starts and ends July 18th at 10:59.
Okay, and then the appeal for that just has a couple days after, so I think we're good with that.
That's correct.
So is the final exam written, or is it multiple choice, or what is?
It will be multiple choice and it will be cumulative. So we'll cover the topics under exams 1 through 5. So it's, you know, you'll need to look backwards. Now, what I'm considering though is extending. Would it help if I extended the time a little bit? I mean, is that just more suffering, or what can I do to make it easier for you all?
More suffering.
Okay. So 2 hours isn't long enough. If I made it 3 hours, would that be more fair?
Do you mean the extent, like while you're in it, how long it lasts?
Yeah, for how long it lasts.
Oh yeah, can you make it 3 hours?
Yeah, that'd be great. Actually, if that part's longer, just don't extend the due date.
No. I have to have final grades in early the following week because the business department goes on vacation and they won't help us with paper-based grades until the fall. So we have a strict schedule there. But I'm happy to extend the time for the exam. I don't think 2 hours is very fair when it's a cumulative exam. So they've been giving, for example, the ADA students 3 hours to do the test. I think that's fair if the whole class got something like that.
Yeah,
Okay, I'll do that.
And Did it already tell us? I know you said it's multiple choice.
Yes. Yes.
And then does it say like how many are within that 3 hours?
It's going to be the same number of questions.
Okay, that's great. 3 hours is great.
Yeah, 25. So you'll have just an extra hour to do it. And because you all came, I actually chose most of the exam questions, and I'm not going to give you the answers, but I'm going to read to you a few of the questions, if that's okay. That help you?
Oh, that would be awesome.
Because you came.
That is good, but let me make sure I'm prepared. Okay.
So it'll give you a flavor for it. I mean, I'll read maybe 3 or 4 questions, and that way you'll get a sense of it. I mean, it's going to be similar to what we've done before.
Okay. Can we do some scoring on the questions? So if we like the one you asked, we can give it a 10. If we don't like it, we can give it like a 0. And then you have to provide us with another.
Sure. Yeah. If you don't.
I'm just teasing. I'm only teasing.
Yeah, sure. Well, I want it to be fair. I don't like when teachers give like a final exam and then run away for the summer, and there's no, because at least with the other exams you could say, look, that wasn't fair, and I could tweak things. With this, with the final, things end, and then the grade is what it is, and it's really hard for things to change. So I feel like this one we should have a little bit more back and forth right now, rather than over the summer, having to deal with looking backwards, because it's too hard to change things after that. So
we do get to do an appeal for the final.
Yes, you do.
Yeah, so really, I was just joking. I will take what you can give me.
Well, I know, and you've been really good. I mean, this semester we've had technical issues. I think there was a textbook issue. So I want to be fair here. For example, the first question is on subject matter jurisdiction, and let me see if I can pull it up here. So the question goes: the boring test pilots, so instead of Boeing, it's the boring test pilots, both lived with their families in Michigan. Boring headquarters were located in Colorado. In which court or courts could the test pilots' families bring their lawsuit? If there were some sort of lawsuit. So boring test pilots both lived with their families in Michigan. Boring headquarters were located in Colorado. In which court or courts could the test pilots' families bring their lawsuit if, for example, the plane went down while the test pilots were testing planes? And it looks like I've got some of the answers up too. So one would be, in a state trial court in Michigan, only because torts are based on state laws and pilots were Michigan residents. Another one is in federal trial court, only because tort law is federal law. In federal trial court, only because diversity of citizenship jurisdiction. In Colorado state trial court, only because torts are based on state. So you get the idea. I'm not going to give you the answer now, but you can see that in this case, you'd have to think through, the state, the diversity issue here.
Okay. Thank you.
Yeah, another one, mediation versus arbitration. Going back again. What would be the difference between using arbitration versus mediation to resolve the dispute with the pilots' families? One answer was about $500,000. Another answer was an arbitrator is used when the parties do not have attorneys. A mediator is used when the parties do have attorneys. Third one is an arbitrator is typically a paid professional. A mediator is normally a volunteer or friend. And the fourth one, a mediator asks questions and gives advice. An arbitrator makes a final decision. Okay, and on that one, Do you guys have an idea of what that would be?
Can you get 130 one more time? Sorry, I couldn't write fast enough.
So
5K.
first answer was about $500,000 is the difference between mediation and arbitration.
Okay.
Second one is an arbitrator is used when the parties do not have attorneys. A mediator is used when the parties do have attorneys. Third one, an arbitrator is typically a paid professional. A mediator is normally a volunteer or friend. And the fourth one, a mediator asks questions and gives advice. An arbitrator makes a final decision. On that one, I'll give you the answer if you don't already know it. Do you guys know the answer to that one?
Well, so I know how to eliminate what I think is not right. So we don't really know how much money difference it would make, right?
Mm-hmm.
So, and
I would say either used when the arbitrator used with no attorney.
Yeah, an arbitrator, I mean, you can bring an attorney to either one, so it doesn't really matter. Mediator really, actually it's usually the opposite. An arbitrator, you do bring an attorney. Mediator, you don't, because mediator just is the middle. It's just trying to get the parties to agree. That's all they really can do.
okay, but with either, they could have an attorney, right?
Excuse me?
With either of them, they could also have an attorney.
That's correct. Oftentimes, you know, somebody will bring an attorney. You can bring one if you want representation, if you want either one.
Okay, and a mediator is not really a volunteer.
That's correct. Usually somebody who specializes in mediation.
Okay, and they, without actually double checking my answer, mediators do give advice, right? They do ask questions and give advice.
That's correct. And an arbitrator
I'm sorry, and an arbitrator what?
does make a final decision.
Okay. And then the other one, I do not know what I just wrote. It says arbitrator something.
So that fourth one is a mediator asks questions and gives advice. An arbitrator makes a final decision.
Is
Oh, that's
that
all
one?
one. Okay.
That's all in one.
So that's
The third, excuse me?
so that's the correct one?
Yeah, that's correct.
Okay.
Third one is an arbitrator is typically a paid professional or a mediator is normally a volunteer or friend.
Okay. Paid was the word I couldn't read. That was it. Okay, great. Thank you.
Yeah. Let's do just a couple more to get you along here. About consequential damages.
Okay. Before you ask the question, can I ask some questions?
Sure.
Because I think where I am not positive when I go to take the exams, I'm not always positive I'm finding the right spots that say, and they can get damages, or no, they would just get, you know, their attorney fees and that kind of thing. Is there something that you can say that helps me get in my head? Yeah, like even if I think I look it up in the book, I may not always be knowing, like, well, it says this here and it says this right here, and I don't know for sure which one to pick. So I pick one. And sometimes that, you know, works out and sometimes it doesn't.
Yeah. If if there has been a contract and you determine that there was a contract, there was offer acceptance, and there was there was the right elements for a contract based on what we've learned, and usually that's offer acceptance and consideration. Those three elements are met. Then there's typically damages awarded if I mean, you say typically because a lot of times a court might say, well, I'm going to award specific performance, which is a way of saying it's not really damages, but it's just saying I'm going to force that carpenter who's saying I don't want to finish the last 5% of the house. There have been judges that have said, no, you will finish the house. Instead of paying the family, you'll just go there and you will finish the house, like you said you would. And they award what's called.
Okay, so on a contract, they would get. Are you saying they would probably just get damages?
Yeah, but usually it's damages, almost always, but it's what kind of damages. So over the history of time, all these new kinds of damages have started to appear. At first, it was just, there was just basically damages, which is, what people would make them whole. But then you'd have things like consequential damages that all of a sudden some court came up with, but a lot of other courts would follow. The typical consequential damage would be, well, I had a contract with Mary, and I signed it. I agreed to build Mary's recording studio, and Mary was going to use it to record her voice, but I didn't finish the recording studio. I breached the contract, and then Mary not only didn't have her recording studio, which she paid me for. She paid me $300,000 to do, and I didn't ever do it. So she should get her $300,000 back, or whatever would make her whole. The difference between what I didn't finish and what, if I finished 90% of it, then obviously she gets that, plus I should pay her damages of the other 10% to make her whole, because you shouldn't get more than that. That would be unfair to me if I have to pay you all $300,000 back, and you get the property with the big development that's almost done on it. But let's say you can prove that consequentially, because you weren't able to record your voice, you weren't able to record a hit song that would have made you another $1 million. If you can, now a lot of times it's hard to prove consequential damages, but some courts will actually listen to that argument and actually award $1 million against me, as well as the 10% that I need to pay you for what I didn't finish in your recording studio, saying that, yes, she has a beautiful voice. She's been able to prove that. Yes, she wrote a beautiful, wonderful song that obviously was going to be a hit song, and Sony Records were just about to sign her up. They had a contract with her. All she needed to do was record it in her studio and give it to them to play on these radio stations, and they would have given her $1 million. But because of my breach, it consequentially resulted in Mary not getting that extra $1 million. It's hard to prove, but that's a consequential damage. It's not a real damage. Your real damage that you paid me for is the recording studio. But a consequence of me not building that is you not getting that song recorded. And you might say, well, that's silly. Why should I be able to recover for that? You may have told me, look, Dan, you got to build this. You got to build by this date because I'm supposed to record this song. And I've got a Sony record contract that's on the line for it. You may have warned me and notified me, and I may have greedily taken that $300,000 knowing that you had this on the line. So I don't know if that helps you, but there's all sorts of facts where you could say, as a consequence of me being lazy and not getting it done, you actually were burdened and damaged well beyond just the little bit of the recording studio that I didn't finish.
I'm sorry. I had to take a call from my boss. What question are we on?
We're on consequence of damage. Can you hold on just 1 second here?
Yeah.
So Lisa, we didn't go into the actual question yet. It was a question that I asked for clarify for stuff before I went on.
Okay, so this is just the third question. Cool. Thank you. Oh, it's so hot in here.
Okay. Can you still hear me?
Yes.
Okay. So I want to give you the actual exam question then. Let's see. So this is, so as you can see, the final, what it does is it gives you a fact pattern. This is Boring Airlines instead of Boeing, and it'll give you a fact pattern at the beginning, and then all of the 25 questions will relate to Boring Airlines. Okay, and so every question will have something to do with their location in Michigan versus their headquarters in, their test pilots in Michigan versus their testing in Colorado, and things happening all over the country and this and that. So this is the specific question on consequential damages. Could Boring get, this might be hard because you don't know all the facts here yet, but could Boring get Ron to pay for profits it lost because it couldn't sell an additional 929 airline to customers who would like to buy those airlines?
I'm sorry. Boring get what?
Could Boring get Ron to pay for profits it lost because it couldn't get additional 929 airlines to customers who would like to buy them? And I think this might not be a good question to do with us here because you need to know the additional facts of the
So is the story the same one that they've given us for the hypothetical situation, or is it twisted a little bit?
It should be the same one. So you'll get the hypothetical facts at the very beginning. It'll be about a paragraph on Boring, and then all of the, as you move sequentially through the problems, it'll add like a sentence or two to each one, and the questions will add facts to it. That it won't be too complicated, but you'll see how you'll kind of need to build upon the facts in order to answer the questions, multiple choice. So that may not be a good one because I can't give you all of the facts just right now to really help you. Let me see if there's another question that's better. About chapter 11. Ron has gotten itself into a bit of financial trouble by failing to deliver engines to Boring on time. It cannot pay its debts as they fall due. If Rod Ron, that is the supplier, wants to restructure its debts without having to liquidate its entire business, it could first, question number A, use Chapter 11 of the Bankruptcy Code. So just restructuring rather than liquidating or filing with complete bankruptcy, just restructuring. It could first A, use Chapter 11 of the Bankruptcy Code, B, use a Regulation D exemption under Rule 4.2 of the Securities Act. C, use Chapter 7 of the Bankruptcy Code. Or D, use Chapter 13 of the Bankruptcy Code.
Can you repeat the question?
Yeah. So Rodron, the supplier to Boring Airlines, has gotten itself into a bit of financial trouble by failing to deliver engines to Boring Airlines on time. It cannot pay its debt as they fall due. If Rodron wants to restructure its debts without having to liquidate its entire business, it could, A, use Chapter 11 of the Bankruptcy Code.
Okay.
B, yeah, go ahead.
Cannot pay debt. They can either restructure their debts without what?
Without having to liquidate its entire business.
Entire business. Okay, thank you.
It could use Chapter 11, Regulation D exemption under Rule 4.2 of the Securities Act, Chapter 7 of the Bankruptcy Code, or Chapter 13 of the Bankruptcy Code.
Okay, and within the question, it's stating that they were wanting to restructure.
They wanted to restructure, so that's the key word. You just need to quickly look at the UCC Chapter 5 or the 500s under Bankruptcy Code, and it'll pretty quickly give you the one that's the restructuring of businesses. And do you guys remember which chapter it was?
I don't. I was just looking it up while you were redoing it. You have to flip through the book to find what chapter it was.
Yeah.
Chapter 13.
Okay, that's not correct. You'll have to look a little closer. Chapter 13.
Well, Chapter 13 in the book does do bankruptcies. I mean, it has the creditors' rights, protection for debtors, bankruptcies and reorganizations, secured transactions. That's what's in Chapter 13 of the book.
Yeah,
you want to look at which chapter of the Bankruptcy Code. Yeah, so make sure you don't give the chapter of the book.
Oh yeah.
Okay. Yes, gotcha. Thank you.
Okay. So the answer is going to be Chapter 11. So it's going to be A on this one, just to help you out. But 11 is the restructuring. So you'll see it in the news a lot. You know, United or whoever will file a Chapter 11 to try to restructure. You know, give themselves time to get their debts in order so they can pay everybody off without having to completely liquidate their assets in bankruptcy. Okay, let's try one more. Let's do a nice juicy sexual harassment one. Those are always fun, right? No, it's too fact specific. Sorry, you'd have to have the facts again. Let's try one earlier that goes back a little bit, because you have tying and IP and everything on your mind. I want to go back a little to where maybe it'll help you to look at things that we did earlier. Statute of frauds. No, a little fact specific. Sorry, guys. Let's go consideration, maybe. Find one first, and then I'll tell you which one you did look at. Okay, how about this one? Let's do negligence. Remember back to negligence? So the important part whenever you see the word negligence is remembering what the elements of negligence are. Okay? And so the question reads, what will the test pilot's families need to prove to win a negligence suit against boring if it was negligence that caused, there's going to be a fact that they'll give you about the test pilots and a boring plane going down. And the test families whose pilots are dead, they want to sue boring and they need to prove negligence against the airline.
So what will the test pilot's families need to prove what?
To prove negligence.
Okay, that's it.
Yeah, they need to prove negligence, like the airline was negligent.
Okay.
But remember back to chapter 1 when you learned about negligence, there's some elements of negligence. First of all, there has to be a duty. There's usually the 4 elements of duty of care, right? There's a breach of that duty. There's a cause, that the breach of that duty caused something, and there's injury. So if those elements exist, then there's negligence. So any one of those that's missing, you can't prove, a court will throw it out. They'll say, well, you might have somebody very injured or dead at the end. You might have somebody that might have something that caused it. You might even have a breach of some sort that caused it. But if there was no duty from Mary to Lisa, in the beginning, then without a duty of some sort that Mary had to Lisa, then there's no negligence. So make sure you look for those elements of negligence. Those are the 4 things you're always looking for that the book talks about and that the courts will look for in negligence. And so some of these answers are: boring breached its duty of care by failing to take sufficient measures to keep birds away from the test site. So there'll be, in the fact pattern, there'll be some birds that I think flew into the engine and the plane went down. And boring had a duty to keep birds away from the airport, the test airport. And they didn't do it. They let big birds nest around the airport test site. Once those big birds get big enough and they start flying into the engines, you're going to get planes going down and you're going to get people dying. So there's a duty to keep those birds away that boring didn't fulfill. And second answer is boring had a duty of care to keep its employees safe. Third answer, boring's breach was the cause of that plane crash. And the fourth answer, boring knew the breach would likely cause a crash. So those are some of the answers, potential answers, and what you're looking for is an answer that shows there was a duty of some sort, and that negligent, a duty that was breached, and that caused, because of that breach of duty, it caused an injury or death, and that creates negligence. And under that negligence, a court can award large damage sums against someone else.
Okay.
Okay. Does this help you?
Yes, I know what this is going to be about. Yes.
Okay. Are there any questions about the kind of the end of the course, like where we're heading now, and have your teams worked out and nobody's fighting or hating each other or anything?
No, my team's great.
I had a great team, yeah.
Okay, good. Well, you guys are sure finishing strong, and I sure appreciate, both of you. I see Mary especially, but I see you too, Lisa, writing a lot in the discussion board, encouraging other people to with their group projects and presentations and stuff. And sure nice to have you weighing in on that sort of stuff. It's rare to have good, students doing that. So appreciate that.
Thank you.
Thanks. Yeah, well, they're good opportunities to figure out what perspective you didn't see, right? Because isn't that a lot of law? I mean, it's like a perspective, and how do you go with that law to go for what your thoughts were in the first place, or to defend someone that was crazy in the first place, and you got to defend him.
Yeah, and what you said is very true. I mean, sometimes your client is crazy. When I was in litigation, I felt my client was crazy most of the time. When I went to Intel, I feel like, even though it's a Fortune 50 company, I feel like my company's crazy a lot of the time.
Differences of opinions make an argument, right?
Yeah, it's about the argument, and I think the Savior is going to think a lot of us are crazy when he advocates for each of us to come with him in the next kingdom, but that, because we're all imperfect, but that's part of advocacy, is making the argument and trying to, and letting the process, letting the other side make their argument, and at least having whoever makes the decision weigh the sides, like the blind, woman who weighed, the scales of justice. That's the way it works. And so a lot of people are critical of the legal profession and the way it works. I don't know. It could be improved upon, but I don't know what improvement it would make. I think a lot of ways it's a very inspired process. It's a lot better than the medieval times when they would just keep piling stones on top of someone until they would confess of something, or drowning the witch, to see if she was a witch, you'd drown her, and if she drowned, then she wasn't a witch. But if she didn't drown, then she is a witch, so you'd burn her.
Yeah, like, how do you look at that logic?
I'm not sure those are better ways of getting a confession, but I know the legal profession can be improved upon today, and maybe if some of you go into the law, you'll be the ones to help facilitate its improvement. James Faust was a lawyer, and Elder Faust always said, "Boy, the day that judges become corrupt is the day we'll really be in trouble." And so, hopefully, judges will still get paid enough to stay objective, but I worry about that, about them being paid off. And you really have to have objective judges and juries to be able to keep the legal profession alive and well.
Yeah, well, the step is to help prevent any of that, right? But, everybody's looking for a loophole, so you never know. But yeah, hopefully it's their own integrity that gets them to the location of being able to be a judge, but, that they keep that too. Yeah.
My grandfather was a federal judge, and he was paid for life a lot of money. Every year, a lot of money. They paid him a lot, and it was so that it wasn't as much to recognize he was a wise old man or whatever, but it was so that he wouldn't be tempted to take money from the mafia or whoever. And he was sure approached a lot, he said, but you never know. So hopefully, if you're going into business, this class was hopefully helpful, at least to know what types of topics are out there in the business world, whether it's intellectual property or antitrust or contracts or statute of fraud, uniform commercial code, or arbitration, whatever tool you might need in the law to help push your business along, or defend yourself, or stay out of the law completely, because it can be a very expensive, inefficient process to be involved in. But that's what that class is designed for, is just to know what the gotchas are in the law, and either stay away from it or know how to use them for your advantage.
Well, I've liked the structure. The structure of it seems like it wants you to learn it rather than testing to find out what you didn't. learn that week. So I like that it's trying to get you to be familiar. You know, that you may not be the expert, but I like that it's structured more to get you familiar with everything.
That's good advice. Or good commentary. I'll write that up and send that into the course creators and let them know you felt that way, Mary. And please put that in your evaluation too. That always helps us to keep getting the course creators to change the course if you feel like there's things that could be improved on.
Yes, I will do that.
Okay. Good. Is there anything else? No?
I will send you an email when I think of something else. How's that?
Okay.
Need time enough to study and like to go back through that book, like you say, and get in particular where you're looking. Oh, is it open book like the others were?
Yes. Yes.
Okay. Yeah, just being familiar with where to flip quick and that kind of thing. So I'm a horrible note taker, just so you know. My notes never have what will be on the test. So I love open book, but you have to be familiar with where you're going to when it's open book. So
right. Yeah.
Yeah, so that's great.
Good. Well, I'll give it more time. You guys got an extra look into what's going on, so thanks for coming.
Yes, thank you for just giving an idea.
Mm-hmm.
That's great. Thanks.
Sure. Thank you for coming, and we'll talk to you next week. I'll have probably one more of these next week, just in case others need to have any questions.
So would you be doing that then like Monday or Tuesday if the exam's due, or are you doing it after?
I'll probably offer like, Monday or Tuesday, I think, around this same time period, don't you think? Because this seems to be the only time people can really come. I think even 4:30, 5:30 was hard for you, right, Mary?
Mine all just depends on the day, you know. So usually, because I work from home, so it just depends on what is expected that way. So if I can pop off of work and pop on, it just depends on if there's a meeting or an appointment or something. So.
Okay.
So, yeah, next week I doubt that I would have another meeting at this time, either day. So, yeah, that'll work.
Okay. I'll send it out and I'll ask if we should have around see if anybody's interested in do away with it. We'll see.
Sounds good. Okay, thanks so much.
Okay, thank you.
All right, you have a good night.
You too, Mary. Bye, Lisa.
Bye.